very important to make sure that the facts of the underlying case here are clear. As I mentioned yesterday, cases like this shouldn't be tried in the court of public opinion. They're meant to be tried in a court of law. But over the last few weeks, as the family has patiently waited for the wheels of justice to turn in a righteous direction, they have been rewarded with misinformation and misrepresentations by the defense, and until now, silence from the prosecution. The reality is that the prosecutors and the detectives worked on this case, spoke with countless witnesses, canvassed the neighborhood, obtained video evidence, ran forensic tests, and only after a comprehensive, thorough investigation that they presented to the grand jury in Baltimore City did they seek and ultimately obtain charges for murder in the first degree. The original plea offer, a standard plea offer for a murder case, notwithstanding the circumstances of this case, was extended to defense counsel, life suspended, all but 60 years. Ms. Mosby claimed that the prosecutor had gone rogue. We now know that that was a standard offer that was done in countless cases consistent with the protocols and policies of the state's attorney's office for Baltimore City. That grand jury got a chance to hear and see evidence that the public still does not have. The prosecutors presented two videos, one from a dash cam of a vehicle that was traveling towards the intersection, a second video from CCTV camera that was able to capture the moments before, during, and after this terrible murder. It was on the basis of that evidence that the grand jury for Baltimore City considered charges for murder in the first degree and ultimately returned those charges. A fiction has been presented to the public, a fiction that the victim was some crazed, intoxicated, bat-wielding maniac who viciously attacked a number of children, and that the children, in the heat of the moment, in self-defense, in a lapse of judgment, fired back because they had to. The evidence that you're going to hear and see today will make it very clear that nothing could be further from the truth. The victim's family wants me to emphasize, and I think it's important for me to take a moment to stress, that no one is oblivious to the tragedy of this case. It involves a young man who was 14 at the time, 15 today, who made a terrible, terrible decision. Some of those decisions are mistakes. Some of those decisions are crimes. And once, under the Maryland law, a person is charged with first-degree murder because of the evidence that was presented to the grand jury, his youth, this defendant's tender age, ought to be a consideration. The victim's family agrees that it ought to weigh on the judge at sentencing. It ought to be a mitigating consideration as to what penalty is appropriate. But to pretend this was manslaughter, to pretend the victim was some perpetrator, to claim publicly, repeatedly, that the defendant was driving while intoxicated is not just false, it's irresponsible. It tries to taint a jury pool. Well, now the defense seems to acknowledge that their client did do it. They're prepared to plead guilty to manslaughter. Well, they've seen the video too. The prosecution has, the detectives have, the defense has, and yesterday, just yesterday for the first time, the victim's family members took the very difficult step of watching for themselves to see what happened. And they want the world to know and the public to see why it is that they are fighting with everything in them for the memory of Timothy Reynolds. What I'm about to share with you today, I don't believe is public, but it is a matter of public record. These are stills and information contained in a filing that was submitted by the prosecution yesterday in the Circuit Court for Baltimore City. This is now a matter of public record. I could have just sent it to you all. Forgive me for not taking that step. After consulting with the family, we thought it was important to explain what exactly is in this filing. So unless there's any preliminary questions, I'm going to go ahead and pull up page by page the 13-page filing submitted by prosecutors in this case. Any preliminary questions?
Sorry.
Of course.
Will we see any of the video, or will it just be the stills from the video?
All we have is stills.
Okay.
The only thing that's submitted is stills. And I will make an ardent case. I hope all of you as members of the media will make an ardent case that at this juncture it is appropriate for prosecutors or the police to release the full video to the public domain. The Maryland Public Information Act has an investigative privilege, but the investigation is over. This is about to be pled out. The defense has seen it. The victims have seen it. I don't know why or what interest we're serving in not keeping this hidden, which is why the family urges the prosecutors and urges the detectives to release this. But at this time, this is all we have.
Will you release the autopsy?
We will release everything that we have, which is just this filing. So
can we get a copy of the autopsy? Because that's in dispute.
We don't have a copy of the autopsy. Anything that is in the public record, we encourage the prosecution and the prosecutors and the detectives to release, but all we have is what we have, David. Okay.
So you'll provide the full filing?
We will provide a full filing of this. I just wanted to, forgive me, walk through it first. But yes, you'll get a PDF copy to anyone who's here. This is the first page. Just want to flag two things. One is that this was filed yesterday afternoon on November 14th. And on the very first page, the prosecutor's filing writes, on August 2nd, upon presentation to the grand jury with instruction on the law and full presentation of the video footage and evidence, a Baltimore City grand jury indicted the defendant on murder in the first degree of victim Timothy Reynolds. They included that because the line prosecutors and the detectives wanted everyone to know that the grand jury wasn't just given some superficial cover story about what happened. The grand jury themselves watched the video that now they are unwilling to release to the public. These are some of the photos. Please feel free to zoom in.
Just leave it there for a while.
Of course. The first photo on the far left is a photo of the street, of the intersection. This is on Conway and Light, where you see a number of individuals, including one who's identified as the defendant, squeegeeing. As many of you know, this same day, earlier in the morning, a state senator called, police were dispatched to this corner. They obtained a BB gun off of another squeegee worker. But these individuals were working right after that engagement by police back on the streets with no supervision and certainly no deterrent. The second photo, this is on page 3 of the document, shows the victim's vehicle passing through. This is essentially coming from Camden Yards towards the harbor. There's another still photo. This is all from the CCTV, which has not yet been released, where you see the defendant actually engage the victim's vehicle. We don't know, of course, what was said or what was discussed, but there is evidence that they had an initial interaction. And it's somewhat obscured by the large box truck, but the defendant is actually leaning on the victim's vehicle, which certainly suggests that there was some conversation between the defendant and the victim. As the prosecutors write, there's no volume on the video footage, but when the light turns green, the victim's car turns left onto Light Street, and the victim parks his car on the far side of Light Street after making that left turn. the victim exits his car and walks across Light Street with the bat held downward. Guys got enough of that? These are the next 3 pages of the filing, and literally that is page 1, 2, and 3 of the next 3 pages. So some of the pages are just photographs. The first one shows in the red box a bag which the defendant collects a few moments later that has the gun inside of it. And we'll talk more about that bag shortly. It's on the south side of East Conway. 414 Light Street, the large corporate tower, is over here. Do you remember? The large residential tower is over there. During the encounter, the defendant, and again, I'm quoting the state's submission, the defendant picks up the bag after realizing that the victim has parked and was exiting the vehicle. Important to note, in a case where self-defense was an original defense, that the defendant is walking toward where the victim is coming, having secured the bag with the gun in it. The defendant puts the backpack on the front of his body and walks towards where the victim and other squeegee workers are already engaging. And again, I'm just going to read. Around the same time that the victim has parked his car, the defendant has run over to the south side of Conway and Light Street and retrieved a book bag which was sitting near a fire hydrant. Defendant runs to join the group of squeegee workers arguing with the victim. This is important. After that initial engagement, that initial confrontation, the defendant then runs back over behind where the UPS truck is parked, close to the area where the defendant had retrieved the backpack. The defendant then pauses and pulls a ski mask down over his face. And again, this is clearer in the live action video, but this is the state's narration. This is not the victim's family. This is the submission that the line prosecutors filed with the court just yesterday. I'm just going to let you see the photo, which is the mask pulled over the defendant's face. So essentially, after he gets the bag, he goes over, engages with the victim, then runs back to where he is out of sight, pulls the mask down, and then re-engages. And again, as the prosecutors narrate, as the victim is walking back across the street toward his car, he is being followed by 3 squeegee workers, including the defendant, who is wearing a very distinctive peach t-shirt. It's the same t-shirt you see in the still where they are doing squeegee work earlier in the day. It's the same t-shirt he is wearing when he picks up the backpack. Again, the CCTV video shows just what the dash cam video shows, which is the victim is walking back across the street toward his car, and he's being followed by the defendant and 2 others. The defendant now with a mask over his face, having retrieved the bag. The defendant is wearing the backpack that he retrieved across the front of his chest. About halfway across the street, as the victim is walking away, one of the squeegee workers starts throwing rocks at the victim. The squeegee workers at that point have formed a half circle around the victim. The victim turns around and moves towards the squeegee workers, swinging his bat once over his head. Timothy Reynolds takes 1 swing. He does not make contact, but he does take 1 swing as he is approached and is circled by these 3 individuals. At that moment, a second squeegee worker runs up and hits the victim directly in the head with a brick or a piece of concrete. We do not know which. That object, according to the autopsy as I understand it, leaves a 1.5-inch deep cut on the victim's head. And as you see in the dash cam video as well as the CCTV video, in the dash cam video, excuse me, not on the CCTV video, he is then stumbling. He has been struck in the head, creating a 1.5-inch gash by a piece of brick or concrete. He is literally stumbling. Clearly disoriented from that hit, the victim spins around and wobbles, tries to gain his balance. I'm just going to go ahead and the carryover paragraph is this from 9 to 10. Clearly disoriented from the hit, the victim spins around and wobbles, trying to gain his balance. At that point, the victim is holding the bat up in the air, trying to steady himself before he starts to fall. The defendant, who is the furthest away from the victim, can be seen in the video footage shooting the victim as the victim is turning away from the defendant. The defendant is the one furthest away from the victim, and he is seen in the video footage shooting the victim as the victim is turning away. Not swinging, not threatening anyone, but turning away. Photos on the right, these are a couple of the last pages, and we'll zoom in a moment. Is the victim then running away, again with the mask? After the shooting, the defendant is seen running back across East Conway with the face mask still pulled down and the book bag across his chest. The carryover paragraph explains that the defendant then continues to shoot the victim a total of 5 times. I am told that at least three of the victim's wounds are on his back. The defendant shot him 5 times.
Could you go back to the photo again? Thank you.
The defendant shot him 5 times while he was turning away. At least 3 of the bullets are deposited in the victim's back. There are casings recovered from the scene. This, I think, is important not just to the family, but to the public as well, because the narrative that the defense team has been suggesting that Mr. Reynolds was not in a position to drive is just false. It's irresponsible. An autopsy was performed. That autopsy was provided to defense, and they've just misquoted it. And to the prosecution's credit, in their filing, they clarify. An autopsy was performed on the victim, Timothy Reynolds. Counter to the defense counsel's misrepresentations, the victim's blood heart alcohol level was 0.03, not 0.1. 0.03, of course, is well below the legal limit. The last couple of pages, they explain that the backpack was found a small distance away. A loaded 9mm polymer 80 was located inside the book bag. After a forensic firearm examination, it was confirmed that this is the firearm that was used during the shooting. The defendant's DNA was found on the strap of that backpack. Through investigation, the officers were able to determine that the individual had actually had an engagement with the police a couple of days earlier. This, of course, happened on July 7th. On July 4th, the officer recognized him, and on body-worn camera, they were able to identify him. That was part of how they made the initial identification. I hope you understand that no one takes any pleasure, certainly not me, in reliving the horrific facts of July 7th. I've asked the victims' family members to listen to this again because they want you to understand how important it is for the truth of what happened to come out. Ms. Mosby issued a statement yesterday explaining that there was another case involving the Inner Harbor where another young man was charged with murder. And in that case, too, even after seeking and obtaining a first-degree murder charge from the grand jury just a few months ago, she walked into court, or her prosecutor, under her direction, walked into court and stood silent, assenting to the transfer back to juvenile, presumably because of the youth of the defendant. In that case, Judge Dorsey rejected the state's attorney's position and kept the case in adult court, in part because the victims vehemently objected. This has become a pattern where Ms. Mosby no longer follows the law of Maryland, no longer listens to the calls of the community, no longer hears or even consults with the victims and their family members. She just whistles to her own tune. And because she has abdicated her responsibility, because she's chosen to no longer do her job, the judges have had to step in and do theirs. It's not the way it should be. I don't recall an instance where an advocate for the family, a role I have served in the past, has ever had to walk through the evidence in a case. It's what prosecutors are supposed to do. They're supposed to do it not at a press conference. They're supposed to do it in a court of law. But when the prosecutors have abdicated their responsibility, that they've essentially joined their buddies on the defense team, the victims have no choice. They have to listen to this paraded on the television screens. They have to read the horrific things that people have said about their loved one, fueled by lies peddled by their opponents. He wasn't drunk. He didn't hit anyone with a bat. There's no forensic evidence, video evidence, live testimony evidence suggesting that. That doesn't mean that at trial the defense might not find someone who claims such a thing. That's their job at trial, to try to poke holes. I don't begrudge Mr. Gordon or Mr. Brown their prerogative to do that. But to claim that he had a .10 blood alcohol level, that he shouldn't have been driving, when they then have the autopsy report which says something to the contrary, it required a clarification. And I do want to commend the line prosecutors and the detectives in this case, because if you go back to the very first page, they actually explain that the reason they are doing this is to correct the record. It is in response to the inaccurate factual account that has been put out by the defendant, his lawyers, and his supporters. There's a cautionary tale that we are allowing the facts of cases to be litigated in the public forum. There is a warning to be had in this case and others that we are allowing the public's opinion to be formed by motivated opponents where the prosecutors, sometimes by law, are required to be silent, and sometimes, as in this case, by choice, they elect to abdicate their responsibility. The family deserves the truth to be known. Timothy Reynolds deserves his legacy to be protected by the truth. Did he make a grave error in getting out of his car with a baseball bat? Absolutely. The family has themselves said that. But he was walking away when the defendant had retrieved a bag with a gun, pulled down a mask, had one of his accomplices hit him over the head with a brick, and then he got shot 5 times, at least 3 times in the back. When other cases of national significance have individuals bring guns to fights. We don't allow them to claim self-defense. Kyle Rittenhouse was ridiculed by the same kinds of people that are now saying, oh, Timothy Reynolds shouldn't have done this because he brought a gun to the altercation. You don't get to walk into the fray with a gun and a mask on and then later claim that it was self-defense. You don't get to point the gun after your buddy has knocked the victim over the head with a brick and shoot him 5 times and claim that it was a lapse of judgment, that it was an accident, that it was in the moment. And I speak with this level of zeal not because I don't understand the sympathies on the other side. I do. And the judge certainly has a very difficult decision. But the victims deserve the truth to be known. And we don't know how else to get it out there. You deserve to see the video. You deserve to see more than my presentation of the state's presentation of the still images. But for now, at least for now, this needs to be corrected. And if you go back and read all your reporting and watch all your coverage, the amount of times you have allowed the defense attorneys to tell their false story about what happened, I urge you to try to level the playing field. Any questions?
What is your position on the victim's right to be heard or have an input at this point in proceedings as far as a juvenile waiver? I mean, the law is pretty clear about the kind of 5 factors that a judge is supposed to consider when deciding whether to transfer a case to juvenile court versus keeping it in adult court, is it not?
The judge has a legal decision to make. There's no question about that, and there's clear law as to the factors that bear on that. The Maryland Constitution and the victim rights laws also make clear that at any significant hearing, the victim is entitled to be notified of the position of the state, to be notified of their right to participate, and in certain circumstances, including this one, to participate. Judge Dorsey heard from the victims in the case in the last week. The prosecution is prepared to make sure that these victim impact statements are submitted, and we expect and believe it appropriate for the victims to be heard here too.
And what you made it abundantly clear, you and the victim's family made it abundantly clear that they're very upset about the way that this has happened and the posture that we're in now. What exactly do you want to happen? What is the correct way for this to continue from yours and the victim's perspective?
Look, the fact that the plea offer has been extended, it's hard to reverse that, particularly because defense counsels has publicly suggested that they're going to accept the plea offer. But I think the judge needs to be aware of how much of a break from protocol there was, that the victims were not consulted as they are required to be in forming and developing a plea offer. So what we would ask at this point is for the judge to rectify Marilyn Mosby's mistake. She had to happen in Luther Trent. It's had to happen in other cases where Marilyn Mosby, ignoring, abdicating her responsibilities to the victims, have had to be corrected by the judge. This too is a circumstance where the victims hope and pray that just as Judge Dorsey did in the earlier, very similar case just last week, that he will reject the transfer request back to juvenile, and that this will continue to proceed like every other first-degree murder case.
Do you know which courtroom it's going to be held? Is it going to be held in adult, juvenile, and can we attend?
I don't know the details of that. I think you should be allowed to attend, but that's not up to me.
Your response to the defense's argument that this is about services for this victim, the fact that the state has the obligation to give this victim, or the defendant, as many services as a youth as possible. Your response to that statement?
Look, his age is a factor that ought to be considered at sentencing. There's no question about that. But the juvenile justice system is not working. The juvenile adjudication report will be provided to the judge, and I'm not in a position to comment on that, but juveniles have been given chances in the juvenile system, and it's not working. And the notion that he would get sent back down, and I want to be very clear about this because there's been some confusion about this. The prosecutors explained to the victims that realistically, if he is remanded to juvenile custody, he would be in a program for perhaps 9 months, that's how long these programs are, and that he would be out after that on supervised release. In theory, he can be on supervised release until he's 21, that's true, so he would be within the juvenile system from now until potentially the age of 21, but he'd be out on the streets. And we know, unfortunately, how poorly supervised release is going for every other juvenile that's on supervised release. They are recommitting and reoffending every day in this city. So the notion that a person who is charged with first-degree murder is going to be returned to a system where the norm, the practice, is that he will be sent to a program, perhaps out of state, perhaps Cullen. He'll spend 6 to 9 months in that program, and then unless he does something terrible during that 9-month period, he's out on the streets under supervised release. And then maybe he gets caught on another crime, but that is not justice in a case like this. And does this victim, this defendant, like every defendant, adult and juvenile, deserve an opportunity to rehabilitate, an opportunity to receive services? Absolutely. But there is a role for punishment and deterrence as well. And to send a signal to the people of Baltimore that if you're 14 or 15 years old, you can shoot and kill people, whether it's at the Inner Harbor or at Camden Yards in cold blood, and walk back out 9 months later under supervised release, that is a terrible, shameful, unjust signal to send.
A couple of things. Yesterday, in Marilyn Mosby's statement, she said that her office had been in constant contact with the Reynolds family throughout this entire thing. Is that true? And then also the defense says that you saying he could be sent to a facility for up to 9 months, they said they have no idea where you got that number from.
Yeah. Well, we got it from the prosecutors. We got it from our understanding and experience of the juvenile system. I welcome someone telling me that there's some juvenile who was committed to custody and spent 5 years in custody. I don't know of an example like that. That's not how the juvenile system works in the state of Maryland. They are under supervision, but they attend a program, and as long as they complete that program, they are then released under supervision. What was your first question, Mackenzie? Oh, the line prosecutors and the line detectives have done terrific work communicating with the victims. But be clear, and I'm trying not to throw anyone under the bus, under direction of the state's attorney, this offer was communicated to the defense first, and only after that was the victims made aware of it. So I'm certainly pleased, and I know the victims are gratified, that the line prosecutors and the detectives let them know about the grand jury indictment, let them know about the bail hearing, but that vital step of being consulted before a plea offer was extended did not happen. And I ask you to ask Marilyn Mosby, did they talk with the victims as they are required to do before forming and extending a plea offer in this case? And by the way, this isn't an anomaly anymore. This is what Marilyn Mosby does. She's done it in case after case after case. The victims are the afterthought. In the Luther Trent case, one of the victims got a call that morning while she was on Zoom. The other victim didn't get a call at all. In the Adnan Syed case, the victim got told about a case on a Friday for a Monday hearing and wasn't told that he could participate. This has become a pattern in Ms. Mosby's office, especially in these last couple of months. She's got a federal trial on her horizon. She's headed out of office. I don't know where her mind is, but her mind is not on doing her job.
Has the prosecution presented any evidence or suggestion where the gun came from? Have police even looked for where the gun came from?
I don't have any information on that.
So you say you want the videos released publicly, but to the best of our knowledge, we still don't have video of what actually happened after Reynolds got out of his car. In fact, in those stills, it's looking down Conway, he turns onto light, and we still don't see what happened. So even if it is released to the public, based on eyewitness testimony, there may be some out there who say, well, we're still not seeing what happened prior to the teenager getting the gun and going over. So what do you say to those people who may have a different interpretation?
It's an important question, and bear in mind that what you've been shown today are the still images contained in the state's filing from yesterday. There is also dash cam video, which I know a number of you have seen. The victims' family members were also accorded the courtesy of being able to see those, and on those you do see the interaction between Timothy Reynolds and the squeegee workers, particularly as he is walking away. You do see him take one swing. But you also see that he does not make contact with anyone. And remember that they have spoken with the detectives. I have spoken with the detectives. To our knowledge, the detectives have not found a single witness who has said they saw Timothy Reynolds make contact with that bat to anyone. And by the way, there's no other victim that's come forward and said, oh my God, look at this bruise on my arm. There's nobody that's, that fell down at the scene. There's literally no evidence except for the defendant's claim that they found some people, either forensic evidence, video evidence, testimony evidence from the dozens of individuals the detectives canvassed and spoke with, that anybody was struck by Timothy Reynolds' bat.
So I just have a follow-up. So will we be able to see from start to finish a visual of what exactly happened to the time that Reynolds got out of his car in its entirety from start to finish? Because you say he waved the bat, but what happened prior to that? Was that after the initial interaction with the squeegee workers?
I have not seen video of the initial interaction. What we have seen video of is the victim walking away towards his car, and video of the defendant going and retrieving a gun, pulling his mask, and approaching him. You do see the individual hit him in the head with the brick. You do see the defendant shoot him from 5 or 10 feet away while the victim's back is to the defendant.
Do we know if any video of that exists, of the initial?
I do not know.
I think you said that, please correct me if I'm wrong, that you and the family are hoping that the judge would reject the transfer to juvenile court and that the case would proceed like any other first-degree murder case. Is there a particular sentence or punishment that you or the family thinks is appropriate in this case or would be seeking?
Candidly, I don't think we have had a chance to have that conversation. I think that the victims understandably believe that a serious, significant sentence is appropriate in a case like this. But candidly, that's the kind of conversation that ought to happen between the prosecutors, the detectives, and the victims. They just haven't had that chance. They were never accorded that opportunity. Maybe there are other strengths or weaknesses to the case, but that conversation, the conversation that's supposed to happen under the Maryland Constitution, under the Maryland Victim Rights Laws, in every case, has not happened in this case. So Dylan, I don't have an answer for what they want at this moment.
Will we hear from the family on Thursday?
I expect that you will.
This may just be a point of clarification for lay people such as myself. Is there any significance to the term blood heart alcohol level? We always hear about BAC. Is there any difference? Is that just how it's reported in autopsy, the toxicology report?
I don't know it any better than you do. I read it as I saw it, and I did see that, but I don't know if that was a typo or if that's what they referenced.
Was there any communication with Timothy Reynolds to anybody prior to the shooting? Did he pick up the phone and say, I'm going to be late, or anything along those lines?
I don't have any information about that. Thank you, everyone, for coming. Thank you for paying attention to this case. I do appreciate it, and the family appreciates it. I just will end by saying this. The family is so grateful for the outpouring of support that they have received from the beginning, but especially in the last couple of days as they have taken the courageous step of breaking their silence and coming forward. The outpouring of love and support as the true facts of this come out, they are forever grateful. Thank you, everyone.